With your host, Andrew Donaldson. This is Heard Tell.
Welcome back to Heard Tell. She's one of our favorites. Been a while since we've had her. Glad to have her now. She's the senior editor at ordinary-times.com, a fabulous writer. She is also a double mountaineer graduate of WVU, including the law school, which is what we're going to be talking to her about. She is a practicing attorney. Em Carpenter, how are you, my friend?
I'm well, thank you. How are you?
We're doing fantastic. Okay, so we're going through the confirmation hearings for Ketanji Brown Jackson. We have the normal silliness, which we'll get into in a minute. But first, let's start with something basic. You went to law school. I did not. So we have something that's going on. I think it's becoming a little bit like our HIPAA discussion and like Nuremberg codes and some other things that you rail on, where people start using a legal term to sound like they know what they're talking about with legal things, but they have no idea what they're talking about. That guy that has that program that I don't like to talk about is once again bringing up and demanding that we see Judge Jackson's LSAT scores. Would you please, slowly, with small words for the people from Logan and the folks out in Overflow that couldn't get into the service, what the LSAT is, what it isn't, and what it does and does not apply to?
Sure. The LSAT is the law school aptitude test. It's basically the SATs for law school that you take, and after you finish college and you're trying to get into law school, you take the LSAT. It's an entrance exam. It's nothing more than that. It has nothing to do with one's aptitude to be a judge or their knowledge of the law or how they apply the law. There are no legal questions on the LSAT. There's no they don't assume any pre-knowledge of the law when you take the LSAT. It's more of reading comprehension. My favorite part of it is logic puzzles. Those that say there are 5 people sitting at a table. The person in red is sitting next to Jim. Jim is not wearing blue. The blue is sitting at the end. Things like that. You got to figure out what order the people are sitting in. Logic puzzles. Love those. That's what the LSAT is. So to be demanding the LSAT scores of a Supreme Court nominee is like asking for the SAT scores when somebody's applying for a job. They may want your college transcripts, they may want your grades, but no one asks what your SAT scores were unless you're trying to get into college. So it's really seems like a pathetic reach if that's the best they can do is, well, you won't tell us what your LSAT scores were. That's pathetic.
Wait a minute. Now, there's no legal questions on the LSAT.
No, because this is a test you take before you go to law school. They don't expect you to know anything about the law before you go to law school. This is just sort of are you smart enough to be successful in law school? That's the point of this. Can you comprehend? Can you logically parse the facts and come up with a conclusion that makes sense? It has nothing there is no legal questions on the LSAT.
So why even bring that up? I know the answer. This is a rhetorical question because, insipidous dullards want to lie to you and make it sound like there's something insidious here when there is not. I kind of compare it to I was in the military. So you take an ASVAB, a lot of high school students do. You take the ASVAB, it's a placement and to tell people try to get some insight into your abilities, but that had absolutely nothing to do with my military career. It had nothing to do with the rank I achieved. It had nothing to do with how I performed my duties. The SAT, ACT, we've had a lot of discussions over that. I don't even know what to say about it. It's just so insipidly stupid to demand the LSAT. Is it just a legalese? That's why I compared it to you ranting about HIPAA. I think it's just really people wanting to sound smart when they're not. And in this particular case, with this particular talking head who knows well and good that it's nonsense, trying to fool people into thinking you're saying something legalese when it really isn't.
Exactly. And this is another instance, and it baffles me that people don't understand this, of people who know better, that think you don't know better, and they are counting on you not knowing better, which means basically he thinks his audience is stupid. So there's no other way to explain it for me. You have to think your audience is stupid to say something like that and expect it to be influential to the people who are hearing it. And why is he doing this? Because best I can tell, he can't find anything else. That it's just such a reach that I can't fathom why else he would be going for that angle of things. And I'll just add that if Judge Jackson, I believe she went to Harvard, I'm going to say that if she did release her LSAT score, it would probably be pretty darn good.
Yeah, she was a year behind. She was a year apart from Ted Cruz, among other people. Interestingly enough. Okay, so let's talk about these hearings because we've already bashed these to pieces. We talked about it during the Kavanaugh hearings. We talked about it during the Amy Coney Barrett hearings. The stuff that happens on the dais aimed at the nominee is mostly nonsense. We don't really learn a lot. But for you, because you do write about these things, you do in-depth studies of these things, we always tell people read stuff for yourself. Let's not skip over the nomenclature here. Where can people actually find this stuff? Because legal opinions, especially at the circuit court level, the appeals court level, this is all public information. This isn't hidden away in, like the criminal court proceeding files where the criminal court, certain things are protected and only lawyers can get into it. This stuff's all public record. Just for the average person that wants to dig into this stuff, that would actually like to read her legal writing, because legal writing has a style to it, just like all other writing. How does somebody find it? Because you find this stuff and then you write about it, so we don't have to read about it. But let's just assume if folks want to find it on their own and they want to turn down the media noise on this and read Judge Jackson's opinion, or any other judge's opinions for that matter, where do they go about finding this information? Because it's all free, it's all out there, and most of it's in PDF form where you can search it.
Right. You can find her Court of Appeals cases, of which there are only 2, and we can get into that. But all of the opinions for the U.S. Court of Appeals for the various circuits can be found online at uscourts.gov. Specifically for DC, it is cadc.uscourts.gov. Those are where her opinions for her very short time on the appellate bench are located. You can also look up the court for the District of Columbia, where you can find her 600 plus opinions issued for her time on the bench, which, there's a lot more of those. So it's all available if you want to look through it. And I've been trying to. Here's the thing with that. I did a deep dive into Amy Coney Barrett when she was the nominee, and she had I think it was 7 years perhaps on the appellate court. So there was plenty of decisions that I could look through and read to try to get some idea of her judicial philosophy or her bent on how she might rule on certain issues, and it's even organized by subject matter. It's pretty easy to find that information. Because Judge Jackson only has 2 opinions from the appellate court, and they're not particularly interesting or influential. One of them is a labor law opinion. I can't remember what the other is. So I had to go then to her time in the district court, and again, she has over 600 of them during that time, and they're not organized by subject matter. They're just organized by date. So I can find her name and see which opinion she wrote, but I have found in clicking through, just kind of randomly trying to find something interesting, a lot of what I'm seeing are just 2-page orders or memorandums that are accompanying an order to dismiss a case. And if you think about it, she's sitting in the district where people are suing the government routinely. And when that happens, you get a lot of crackpot cases. So, we have a lot of short opinions dismissing cases brought by pro se litigants who think the government is spying on them personally, or trying to sue the Department of Justice because their ex-wife is trying to get child support. It just craziness. So it's really hard to dig through all of those things and find interesting or cases that are helpful in trying to form an opinion. They're there. I just have a full-time job, which makes it very hard to find all of them. So There are a few interesting things on there. I can say it's just that it's difficult to find. And so I think that rather than going out and trying to read these things for themselves and trying to dig through these, finding the needles in the haystack of the substance, they're going to pull out things like her LSAT scores. I know Tucker Carlson, I hate to say it, sorry I said the name, he used to not be named, isn't reading any of these opinions. I'm positive.
And one other thing before we move along on it, because of that day job, you have argued in courts and the appeals court level. When people are saying that and they're talking about qualifications, we have different Supreme Court justices. Elena Kagan came from the academic side. Amy Coney Barrett was academic and sat on the bench both. Gorsuch, of course, was well known for his appeals court level and his legal, whether you agree with his philosophy or not. He very brilliant legal writer at the appeals court level. We have different kind of justices. Talk about the qualifications for all that district court work, because some folks were kind of saying, well, she's only been on the appeals court bench for a little less than since June of 2021. That's a lot of experience that is practicable when you're at the Supreme Court level, right?
Yeah, it is. And as far as qualifications, I don't know that there's any one particular set of qualifications. I think it's good to have on the court just sort of a broad background among all of the judges. And yes, we see with Amy Coney Barrett, she has very little practice under her belt. She spent very, very few years of her career actually trying cases or being a trial lawyer or being a practicing attorney, as you think of a practicing attorney. She does have a lot of, and that doesn't necessarily disqualify her, in my opinion, and I didn't think it did back when I was considering her. So that you can be qualified just by being a scholar of the law, by having studied a lot, being a law professor. And it doesn't, just because you've been a professor rather than a practitioner, I don't think would necessarily disqualify you. I think that's fine. But one thing, and it's been talked about a lot, one thing with Judge Jackson that sort of sets her apart is that she was a public defender. She was a criminal defense attorney for the indigent, which is I've said it before, I'm not going to go through it again, but as you know, my opinion, is probably the highest calling of an attorney. And that is a very unique background to have. And I think it's something that's needed on the court. And I think that that would be a very helpful set of expertise that she brings to the bench. That now you want judges that have enough broad base of knowledge that they can meaningfully consider and contemplate and rule on a variety of legal issues. So I think having all of various backgrounds is a positive.
Yeah, talking to Em Carpenter, senior editor at ordinary-times.com and an attorney in her own right. She writes a legal column most weeks, not every week, because of that day job we were talking about. When we come back, we're going to continue to delve into the background of Judge Jackson. We're also going to talk about what we can and can't glean from these hearings. And she has a couple of examples of Judge Jackson's court case writings and opinion writings. One of them that's actually really good that might give you a little insight into her. More with our friend Em Carpenter right after this on Heard Tell. Welcome back to Heard Tell, continuing our conversation with Em Carpenter. She's senior editor at Ordinary Times. She's also an attorney in her own right. Okay, we've talked about it, the background a little bit. When you are digging through these, judges and lawyers, but especially judges when they start getting up into the district level and the appeals court level, they develop a writing style because they understand that other attorneys are reading them. And then when they go to the appeals court level and the Supreme Court level, they understand that people study their opinions. Scalia was kind of infamous for this, that he would write it very much so because he knows people's going to read it. What have you gleaned from her writing style? I know you said a lot of it's just little 2-page things, but you found a couple of examples that really does allow her personality to come out a little bit on top of just her judicial philosophy.
Yeah, one in particular that tickled me, and this is going way back to 2013 when she was fairly new. There was a case in which a pro se plaintiff, Mr. Ratley, had sued the U.S. Postal Service for $341.99 for damage to a package. He claimed, made a claim under the insurance that the Postal Service offered, and he filed it basically in a small claims court for suits against the federal government, the Small Claims and Conciliation Branch of the District of Columbia Superior Court. And the judge in the Superior Court had dismissed the plaintiff, or dismissed the complaint because of bad service. You have to follow certain steps and rules, and when you're serving a complaint against somebody or serving a lawsuit on somebody, and he apparently didn't do what he was supposed to do, and his case was dismissed. Then he decided he was going to go a step further, and he tried to have his case reinstated, and that should have been dismissed at that point. It was a pretty easy call for the court. His case was kind of dead in the water at that point. It could have been gone at that point. But instead of letting that happen, the government lawyers took the inexplicable step of, as Judge Jackson puts it, decided to make a federal case out of it. And they asked that this small claims case be removed to the federal court, to the appeals court. So it just, to put that into context, had the plaintiff filed his complaint in the federal court, it would have cost him $350, which is more than what he was asking for from the post office. So as she writes here, despite having already secured near final dismissal of this matter, the Postal Service inexplicably snatched defeat from the jaws of victory by filing a notice of removal and thereby shifting the plaintiff's motion for reinstatement of the complaint and presumably the entire case into federal court. And so, Judge Jackson could have pretty quickly disposed of this case, saying that removal is improper or for other reasons, but instead she took about 7 pages basically to explain all of the ways in which the federal government was acting stupidly in this case. She says there was a lot of opportunities for the government to have backed off, and now they're going to litigate this case in federal court at a cost far greater than the claimed benefit. The Postal Service vigorously maintains that the agency properly removed the plaintiff's reinstatement for 2 reasons. Because 1, the USPS is a federal agency and was improperly sued in state court, and 2nd, because the plaintiff's motion for reinstatement constitutes a removable civil action. So it wasn't so much that they couldn't remove it, but they didn't have to, and they're wasting a lot of time and money here. And she says, without providing any clues to a broader, more fundamental question, why did the agency determine that removal to federal court, even if valid, was appropriately invoked under the circumstances presented in this case? But she says, nevertheless, the court is persuaded. So she says, okay, we're going to take jurisdiction of this case, and despite the fact that leaving well enough alone would certainly have been the easier, less costly, and more efficient matter for the option of this dispute. Of course, she's saying, had they just left this case in the lower court, it would have been dismissed and it would have been over with. But instead, they're going to spend all this time and money removing it. And if you read the opinion, and it's only 7 pages, it's really actually slyly funny. She's not overtly critical or being rude to the defendants here, to the post office here, but if I was the attorney in this case reading this, I would have felt really dumb when I was done reading it. So it's a good read. It's a good example of her writing. And I think it's one worth looking up. It is, again, it is Ratley, R-A-T-L-E-Y versus United States Postal Service from a 2013 case. Unfortunately, I did follow up to see what happened with this case, and Mr. Ratley, I think, found himself a little overwhelmed by the process and procedure of the U.S. District Court. I kept saying appellate court, but I meant district court. And so he apparently did not follow up and didn't file any more pleadings, and his case was ultimately dismissed, and the U.S. Postal Service won, unfortunately. But it's just good read. It's a good, funny case. It was the only one so far that I found that was really interesting and easy to read and a fun opinion, in my opinion.
Yeah, talking to Em Carpenter, senior editor of Ordinary Times and an attorney who explains legal things so well that even I can understand them. That's fun. A little less fun is some of the stuff going on in the hearings. I don't want to get into the technicalities of the case law because they keep bringing it up and up. But when you hear the senators bringing up the child porn cases and things like this, you've done a review on her now. You're looking through her stuff. How hard do they have to dig to find a case like that, and how applicable is it really to her broader legal theories? Because I know it's scary words because you start talking child molesters and child porn and all these
Mm-hmm.
really scary, ugly, wicked things that do need to be severely punished. Nobody's saying they shouldn't be, but also there's a little bit of a thing here is, you're also dealing with victims. You're often dealing with victims who are victims themselves. There seems to be a little bit of a problem here where they want to talk about judicial discretion as a one-way street when it's not. It's a entirely complicated thing.
Yeah, for the first part of your question about how they had to dig to find this, I feel like somebody put a bug in their ear. Somebody maybe who is involved and was unhappy with the outcome of that case may have alerted them to its existence, because otherwise, yeah, finding that would have been very difficult. Especially in a criminal case, you can find all of these documents online in Pacer. That's the court documents electronic filing system that you can pay and get access to. And every time there's a hearing in a criminal case, and there are a lot of hearings in criminal cases, an order is generated just to say, we were in court this day and this is what happened. So any criminal case probably has dozens of orders, can have up to, maybe dozens of orders listed online. And you would have to you'd be digging through all of these orders, trying to find a sentencing order or a sentencing memorandum. You would really be drilling down through levels of documents and to try to find something that specific. It's not something that you're just going to run across by browsing. So I think probably someone put a bug in someone's ear to look at that particular case, because it does sound icky on the surface. It is hard to, it is an easy one for her opponents to latch onto and make a big deal about, because it is such a sensitive topic, and nobody wants to be on the side of leniently punishing people with child sexual abuse material on their computers. I think in this case, it was an 18-year-old high school student, which may or may not have played into the judge's decision there. Again, yeah, we don't want to get into it too deeply, but judges do have discretion, and quite often they use it in the opposite direction. And they, especially in federal court, some sentences can be really severe, and it's not as common for a downward departure from guidelines to get a lesser sentence, in my experience. So that's an interesting case as well for them to highlight. It's unfortunate that it's this particular topic. I wonder if they looked as hard for perhaps, a white collar criminal whose sentence may have diverged below the sentencing guidelines or below a prosecutor's recommendation, and if they would have made as much of a point of pointing that out. Probably not.
I got a little frustrated listening to it because Senator Josh Hawley, who I hold in high contempt because I don't care for him at all, but he kept arguing with the judge of like, well, Congress's guidelines were this, that, and the other. And he kept coming back to, he's like, well, there's the federal guidelines, and then there's the sentencing guidelines, and then there's the Congress wants this and Congress wants this. And I'm sitting there and I just want to throw something on the TV like, yes, and Congress shouldn't have had a role in any of this, because it was once again a symptom of legislation of do something, of mandatory sentencing, which almost never works out well once it actually goes to the practical level of the criminal court system. But that's another debate for another day, isn't it?
Yeah, I agree.
Talking to Em Carpenter. Before we got to let you go, though, let's go back to Judge Jackson for just a second. She's going to be confirmed. This is all dog and pony shows. She's going to get confirmed. I suspect she'll probably get a couple of Republican votes somewhere in here as well. This is not a flipping of the court. This is a progressive with another progressive who's well in the main line of the progressives. Most legal scholars we've been reading says she's going to be somewhere between Kagan and Sotomayor. She's well within the mainstream of that judicial philosophy. What do you see us going forward with Supreme Court nominees? Because Amy Coney Barrett wasn't quite as bad as Kavanaugh. This one's not boring, but it's more, what does it say to us about our legal system and the way we what does it say about us and our legal system and how we perceive the Supreme Court, that people are almost disappointed that we're having a relatively boring nomination and confirmation hearing? I know we're getting some noise on things like the child sex guidelines and things like that, but this is pretty much a boring one that's not in any doubt. Does it speak really ill to us? Because I think it does, that folks are almost disappointed that this isn't turning into a big free-for-all.
I think so. I think we've gotten used to the drama and the spectacle of it all. And I think that folks like Holly are really doing their best to make it more like the gladiator events, something, watch this person fight the lion. And I think Holly perceives himself to be the lion in this case. So I think, yeah, they're trying really hard to make it interesting. And I know you make a lot of analogies to professional wrestling, and he's trying really hard to make a main event out of this. And unfortunately, yeah, I think there is an appetite for the drama. And, a lot of folks say they don't want it. They want civility and this type of thing to be boring, to go back to the days of, 98-2 confirmations and things like that. It's not where we are right now, unfortunately. And as long as people continue to eat up this kind of contentiousness, it's probably going to continue. It's great for the fundraising for people who are like Holly, who are making big spectacles of themselves and making it about them, as a lot of the people on the other side, and for Kavanaugh and Amy Coney Barrett, they were all giving stump speeches, and that's what this is.
Yeah, to your point, Ruth Bader Ginsburg, nominated August of 93, 96-3 vote. Stephen Breyer, who obviously is apropos to the moment, 87-9 in 1994. It wasn't that long ago, this stuff, like even the Obama era, which was highly polarized, highly political era, Kagan and Sotomayor were both 63-37 and 68-31 respectively, basically the same spread. And then you get into some of the more real contentious one. I remember when they did Alito, which a lot of people had a problem with Alito. Even he, with all that, he was 58-42. It wasn't really close. And a lot of people had, how do I say this kindly, because I know he's not your favorite either, had some legitimate concerns if he was up to we talk about the writing before. A lot of people don't care for Justice Alito's writing. They don't think he's particularly, I don't want to say creative, but he there's been questions about how well he is for the court. But then you get into the Trump years, and Gorsuch and Kavanaugh and Amy Coney Barrett were all basically party line votes, with the exception of Gorsuch. You got about a 10-point spread. I think we're just pretty much in party line votes, and it's going to be like major legislation where you're going to get it. As long as they pass, then you'll get a few deflectors for cover, and it's just turned into one more legislative thing, hadn't it?
Yeah, I agree with you there. I wonder sometimes, it's hard for me to imagine, but what would Ruth Bader Ginsburg's vote have looked like today with her history on civil rights cases and such? I think she would not be in a 96-3 or whatever it was. So it is interesting and unfortunate, I think, that it's turned out this way. I mean, I've always said that in 99% of the cases that come before the Supreme Court, they're not as politically interested in the outcome as we like to think they are. There are some big kind of cultural issue type cases that people pay the most attention to, but a lot of the things that go on, in the court, you get a lot of 9-0, 8-1, 7-2 opinions on things that you would have expected to be more partisan. So I think that these confirmation hearings are more contentious than the actual court itself.
Yeah. Em Carpenter, I rely on you. A lot of other people do. You're a great writer. Let people know where they can find you and follow your writing and your work.
Sure. I'm at Ordinary Times along with you and all of our other friends there. I try to do my Wednesday. I didn't get one done this week, but I had a few last couple of weeks, so I thought I earned a week off. Also on Twitter at WV Esquires. Follow me. It's unfair that you have so many more followers than I do, so it's time for people to jump on the M train.
Yeah, well, I showed up to work this week, so there. Availability is half of greatness. Em Carpenter, I'm giving you a hard time. You do great work, and yeah, you earn a little bit of downtime from time to time. Thank you so much for your insight today.
All right, thank you.
Yes, ma'am.
Now let me see you go off like a bomb.